This is a special opinion piece relating to a short clip that I've taken out of the November 23rd Board of Supervisors meeting. And it addresses the public comment section at the beginning of this meeting. And I will discuss some issues that the Board of Supervisors and Jennifer Savage comments made by them regarding the $2.7 million of the RCC funds that I believe, in my opinion, they mischaracterized. This clip is about 5 minutes long. They will talk about DCED at the beginning of this. I've taken the whole clip from the point where I've asked a question, and then you'll hear their answers. But this clip focuses on the comments made by David Speece, John Cusatis, and Jennifer Savage on the forensic audit conducted on the RCC. Before I start my presentation, and you'll see this first slide, you'll view the video afterwards, 5-minute video, but I want to go over some terms that you will hear Jennifer Savage, John Cusatis, and David Speece use in their discussion so that you will see how they distort the truth. And they're distorting the truth because they want to take your attention away from some very serious matters, which basically are the fact that some books and financial records for this whole thing disappeared. That's the real issue as far as I'm concerned. So let's take a look at the two terms I'm showing you. These nouns, misappropriation and misapplication. So you will hear David Speece, Jennifer Savage, and John Cusatis especially insist on using the term misappropriation. Misappropriation is the wrongful, fraudulent, or corrupt use of others' funds in one's care. And this particularly applies to public officials. The misapplication is the misuse of something incorrectly, using something in a wrong application. And the other difference is that misappropriation assumes that these individuals took this value and used it for personal reasons. This is not the case, as you will see. The evidence will show there is no misappropriation. There is a misuse of the funds, a misapplication. And this was due to the advice by the solicitor. The solicitor was asked if they could use these funds for certain expenses, and the solicitor gave the board their advice, saying, yes, you could do this. And so they followed the solicitor's advice. And the problem is, in the state of Pennsylvania, solicitors are exempt from any responsibility or any legal actions based on giving their advice to the Board of Supervisors. They're exempt from responsibility. Even if it's bad advice, they have no responsibility for that. And that goes for the supervisors as well. As long as they follow the solicitor's advice, rightfully or wrongly, the advice is wrong or good, as long as they follow the solicitor's advice, they're exempt from any responsibility based on what the outcome was. They just followed the solicitor's advice, and that's the best they could do. So they're exempt from responsibility, and that's the case here. There was no misappropriation. There was simply a misapplication, and that misapplication was the result of poor advice from the solicitor. And unfortunately for the taxpayers, we can't hold anyone responsible for that, which is beyond me. So that's item number one. Item number two, what I've done is I've basically just given you the link which you could put in your browser and go see the actual document, the forensic audit report. They call it something different. They call it agreed upon procedures. It's at the Exeter Township website, if you could find it. It's in the documents section. You can also go there. So that's the conclusion of defining these terms. The proper term that should be used is misapplication, not misappropriation. Misappropriation, which Mr. Cusatis loves to throw out there time after time, implies there was some criminal activity, and this is simply not the case. However, you will find, as we discuss later, about missing books and records, that is a separate issue. And the things that happen in this area are not protected. No one is protected by law, yet as far as I know, no investigation, internally or otherwise, has been conducted, and you will not hear the Board of Supervisors ever discuss anything about missing books and records. Now, the next slide we're going to look at has to do with the Township of Exeter summary of testing results. And the first thing you'll notice is that the dates, January 1st, 2005 through December 31st, 2016. So we're looking at 11 years of information. And what I want to point out to you is that this encompasses the funds, the bond funds that were issued, over $18.6 million. A lot of money that these supervisors put the taxpayers on the hook for. And this was used for the Reading Country Club. And in fact, what's going on in this case is that an entire set of books and records, as I discussed earlier, for three funds, Fund 10, 98, and 99, could not be located by the township or its auditors. And the one fund, the Operation Fund, that was the overall fund. I would call that the slush fund. Books and records missing. The Beverage Fund, which was for the restaurant. Also, those books and records are missing. And then, of course, the Golf Course Fund. Those books and records are also missing. Isn't that odd? I mean, in my estimation, missing, gone. You'll never hear Cusatis or Speece or Savage talk about these missing books and records. This is where the real investigation should be, because we know what happened to the money, and they're trying to divert our attention away from the seriousness of this happening. And I can tell you that in my experience, and I've done a lot of audits, I've been involved in uncovering frauds in many different companies. When books and records are missing, somebody took money. Someone took something of value. Now, this isn't a precedent because we know that Vanderlane, Speece, and Cusatis and company, Granger, they went into the sewer plant and took hard drives and any information they could get, and that's all disappeared from the sewer plant. So this is not unusual. When Vanderlane and Speece and Cusatis called for this forensic audit, they could have very well spirited away these books and records. Well, we'll probably never know. Until we get some honest people on the board, there certainly will not be an investigation occurring. So I want to also point out on this next slide, Township of Exeter, you'll see the other name for this forensic audit, agreed upon procedures and findings. And what I'd like to show to you on this is the fact that the monies, $15 million and change, were to be applied to the capital projects. And the problem with this is that not all of it was used as directed. And although the lion's share was used for the purchase of the Reading Country Club, and that was, the original purchase price was around $14 million. So any of the remaining amounts were supposed to be used for capital improvements. And what you will find is that we had very few monies spent on capital improvements. Just ridiculous. It's embarrassing to see how this property and this business was mismanaged, as it is still being mismanaged today. It's been closed. Our food and beverage business has been closed for years. Mr. Cusatis was the guy who seconded the motion to kick Viva out, and he's made sure that no further capital spending was spent on getting that building ready to operate. And it was the only building that made the food and beverage made the money, not the golf course. So in this next slide, this is going to show you the summary of their testing results. And right there it is, the $2.7 million in question. Remember, they're claiming this was misappropriated. I'm claiming it was misapplied. And this schedule confirms what I say is happening. Misapplied, not misappropriated. No supervisor benefited personally from these funds, as you will see. In fact, what we have here, you follow these first two arrows, is we spent $1.8 million, 66% of the $2.7 million, to actually pay back the bond funds. So we borrowed money, and then we used the money to pay back the borrowing. So that's like you taking out a second mortgage and then taking the money, and instead of spending it on house improvements or buying a new car or something, you use it simply to pay back the loan that you took out. It's ridiculous. It's outrageous. Now, Jennifer Savage is saying that, well, the Reading Country Club owes this money back to the general fund, and that's not correct. The bond funds are general obligation bonds. They're in a separate account, which are paid for by the general fund because we have this extra tax in our tax bill to service these funds. So they were using money that should have been used for capital improvements to keep the taxes lower. This is what they've been doing for years. So in my comment piece, as you'll hear it later on, I say, hey, the Reading Country Club doesn't owe the general fund $2.7 million. The general fund owes the Reading Country Club $2.7 million. And you'll hear Jennifer Savage say that I've got it backwards. But look at this, folks. Here's the evidence, and I don't think I have it backwards. These funds were supposed to be spent on capital projects for the Reading Country Club. Obviously, they were not. So I think Jennifer Savage and John Cusatis and David Speece, they're the ones that have it backwards, and they have an agenda that they're pursuing. Don't you believe them? Now, the rest of these funds, $936,000, you'll see that box there. These were all spent for operating expenses. Big portion of it there, you'll see the $650,000, and then the other $249,000 for working capital. We gave this money to a company that we hired to run the golf course. Yeah, we gave them the money. We subsidized their business at taxpayer expense. It's absolutely ridiculous. It boggles my mind why anyone would do this. But you can see here that these funds were spent on operating expenses. So this is why these are potentially unallowable costs, because they were not used for their intended purpose. They were supposed to be used to fix up our country club building, to fix up the golf course, capital improvements. Instead, they used the money to pay back the proceeds from the original bonds that were issued and for operating costs to a third party that they hired. This is the way I see it, and I hope that I've made this quick, brief explanation of what's going on in our township, and it's further proof of the incompetence and the misdirections of Mr. Cusatis, Mr. Speece, and the inexperience of our finance director, Jennifer Savage. They're not being honest with us. They're not being transparent. They're trying to muddy the real reasons why this is a mess. So I'd like to see your input back on this, and please enjoy the 5-minute plus video that follows these slides. Thank you.
Hughes. I live on 47th Street, 5 West 47th Street, and I have a comment about 2 agenda items on the meeting tonight. The first item is the engagement contract with Maley. I think it's a bad idea to contract with them again. You should reconsider for a number of reasons. One of them is certainly the controversy with the DCED report. Even the new report that you gave me with their signature doesn't have a complete date. And I don't believe that they did that. They're not incompetent people. They're CPAs and they're well trained. So something's going on with our department, our township, and Maley. And I think it would be prudent for us to find a new auditor. And then the other agenda item I'd like to discuss is item number 6 under new business, relating to transferring $2.8 million to the RCC clubhouse. That's fine. I mean, I think it needs it. It needs to be fixed up, but you're forgetting something, or at least everyone has forgotten that the misapplied $2.7 million that was spent in other areas, for example, paying back the actual bonds themselves that were issued. That money was never replaced to the Reading Country Club. So you really owe the country club $2.7 million of the misapplied funds. You've never put those back into the Reading Country Club fund. So I'd like to hear your comments on how did you miss that? And what are you going to do? There are other issues on here I'd like to discuss, but of course my 3 minutes prevent me from talking about it. So let's use our heads on this. It's time to find a new auditor and do the right thing. It's common sense. They've been there 3 years. There's issues. Let's do it. Make a decision that makes sense for this township, as well as with the Reading Country Club. And that's the conclusion of my comments for this meeting.
Very good, thanks. And Jen, I don't know, you have comments on Maley. I think you've been pretty happy with them.
I've been very happy with Maley. They have given us no issues. They're always timely with everything, getting back to me. They're great at answering questions. We can go through our recommendations when we get to that item,
Okay.
but no, I have no complaints with them.
Okay, yeah, I think the issue with the date was incomplete, maybe Jeff can comment, a final document that was provided a right to know request that may not had a final seal on it or something.
Correct. I actually was in discussions with our DCED approver today, and the document that Maley had sent to me was an unapproved version of the DCED. It is not approved until Mr. Saunders, our approver, our reviewer, actually designates it as approved in the DCED system. So it is a filed report, but it is not the official copy until he approves it, is what Mr. Saunders told me.
Great, thanks, Jen. I think the 2.7 misapplied funds, I mean, we're still working on an insurance claim on that, and that'll get straightened out when that's done.
Yeah, that actually has to do with bond funding. So, the bond actually proceeds were used to pay expenses of the country club. So it would actually be the reverse of what he was saying, is that the country club would actually owe the bond back because there was operational expenses paid for the country club from the bond proceeds. So it would actually be the reverse. But the misappropriation of funds was it was more of a tax issue than anything with the funds, that there was funding from the bond that was used for non-appropriated items having to do with bond funding. So we remedied that by doing a taxable bond, and that was more of an IRS tax issue, making that whole.
Okay. And that
Yeah,
gets
and
written down.
just to add to that, Jen and Dave, the misappropriation on that issue as well with the previous boards, I did give everything to the DA when we were on the board, Dave, last year. So the DA has all that information to potentially go after the previous board members as well.
Yeah. Yeah, and the misappropriation was just that there were not records or whatever, not.
Correct. That's in the DA's hands.
Yeah. Very good, thanks.